that although the applicant is entitled to review the decision of the President for legality, it must do so without a record. That is the stance that the President has adopted. That is a stance which we respectfully submit is unsupported by any direct authority. We have considered the authorities which our learned friends have put up. None of them, and none that we are able to find, suggests that one can have a review for legality and not be entitled to a record at all. There are debates about the extent of the record, about deliberations, but we are unaware of any decision which says you're entitled to review for legality, but you're not entitled to a record. In fact, as the, can I call it the spy tapes case to avoid the confusion which arises from the multiple cases of similar names, but the spy tapes case, DA versus acting NDPP, says exactly the opposite, and I'm going to demonstrate that to your Lordship in due course. It says, when you are entitled to review for legality, you must be entitled to a record, either under Rule 53 or the inherent jurisdiction. And the reason for that are the cases that are set out in paragraph 29 of our heads of argument, or the explanation that is given about the purpose of a record. So at paragraph 29.1, we quote the Helen Suzman Foundation case, which says that the primary purpose of Rule 53, could I pause there? The Helen Suzman Foundation case was not about a Pudger review, my lord. It was a legality review. And what it said is the primary purpose of Rule 53 is to facilitate and regulate applications for review by granting the aggrieved party seeking to review a decision of an inferior court, administrative functionary, or state organ access to the record of proceedings in which the decision was made, to place relevant evidential material before the court. The rule is an important tool in determining objectively what considerations were probably operative in the mind of the decision maker when he or she made the decision which sought to be reviewed. The applicant must be given access to all the available information, must be given access to the available information sufficient for it to make its case and to place the parties on an equal footing in the assessment of the lawfulness and rationality of such decisions. And what the courts explain time and time again, my lord, is that that is because the decision maker, whose decision is being reviewed, has taken the decision and he or she knows what he considered and what he didn't. But the person reviewing doesn't. If it were not for getting a record under Rule 53, they would have to launch the application in the dark and be placed at a considerable disadvantage. My lord, we've referred to the Turnbull-Jackson case of the Constitutional Court, which says much the same thing. But could I take your lordship to a judgment which is not in the heads, but which is in the bundle of authorities, which is very helpful? It is the decision in Competition Commission versus Compu Ticket. It is the decision of the Supreme Court of Appeal in that regard. Does your lordship have the bundle of authorities to hand? Thank you, my lord. It's the case begins at page 100, but the passage to which I wish to take your lordship is at page 110. Yes, it's a unanimous decision of the SCA. Lord, at page 110, paragraph 18, the court summarizes what the case is about. And the court explains that it was a different context. It was a decision of the Competition Commission to refer a complaint to the Competition Tribunal under the Competition Act. And it was common cause between the parties there, as is here, that that decision was not administrative action, but was subject to review on the basis of the legality principle. And that's what paragraph 18 says. So there, as here, it was conceded by both parties that it wasn't administrative action, but it was reviewable on the legality principle. And then here comes the important point, and it is recorded as a concession, but the court endorses it. As a second step, the Commission also conceded that since the decision to refer is reviewable, that's under legality, Compu Ticket is entitled as a matter of principle to discovery and production of the material that was before the decision maker when that decision was taken. So that's the concession made by the Commission. But then the court goes on. The correctness of that concession appears inter alia from the following statement, and then it quotes the spy tapes case, where the court says, and I'll come back to this, but let me read it because it is fundamental, if I may. it can hardly be argued that the court first refers to Rule 53, and then it says, it can hardly be argued that in an era of greater transparency, accountability, and access to information, a record related to the exercise of public power that can be reviewed should not be made available, whether in terms of Rule 53 or by courts exercising their inherent power to regulate their own process. Without the record, a court cannot perform its constitutionally entrenched review function, with the result that a litigant's right in terms of Section 34 to have a justiciable dispute decided in a fair public hearing before a court with all the issues being ventilated would be infringed. So the court is saying, never mind what Rule 53 says. In this constitutional era, once you can review something under legality, it can hardly be argued that you can't get a record, because it is indispensable both for the court to perform its function and for the party concerned to have a fair hearing. And that is because if we fast forward to the main application, if my client doesn't know exactly what was before the president when he took his decision, and if the court doesn't know, then my client is not able to get a fair hearing, and the court is precluded from properly exercising its judicial function. And I'm going to demonstrate that, if I may, my lord, with reference to the discussion of the intelligence report, the so-called intelligence report, which is an issue, a substantial issue in the main application, and a substantial issue in this, in this compelling application. Because your lordship will know from the main papers, which your lordship has read, and from the compelling application, that what happened in this case, and your lordship need not go there, I'll just give your lordship the reference, but what happened here is that prior to the president making his decision and thereafter, there was considerable concern expressed by senior members of government and of the ANC about the president's apparent reliance on a so-called intelligence report. Could I give your lordship the reference? It's page 21 of the main founding affidavit, paragraphs 46 to 47, and then page 29 through to page 34 of the main application, paragraphs 58 to 61. And if I could just give your lordship in a nutshell what happens. What happens is that the deputy president, and this is paragraph 59.1, is quoted as stating publicly that the dismissal decisions of Mr. Gordhan and Mr. Jonas were based on what he terms, and I quote, a frivolous intelligence report. Then on the same day, Jackson Mthembu, the ANC's chief whip in Parliament, makes a similar statement. He expressed concern that the removal was based on what, and again I quote, on what he calls a suspect intelligence report. Then the ANC's Treasurer General, Mr. Mkhize, makes a similar statement and says he's concerned that it was based on an intelligence report which appears dubious. And then comes the crunch. No, but precisely. Yes. But that's your lordship, with respect, has exactly the point. Because the point that is made at paragraph 60 is, I'm sorry, my lord.
I'm not sure why we are focusing on something that is not relevant.
Because, my lord, the criticism that is leveled by the president is he says, but in your founding affidavit you referred to an intelligence report, so why must I put it up? But the explanation that is given in paragraph 60 is as follows. It says, the president has not disclosed the so-called intelligence report, but the text of what is apparently the report circulated on social media, and then it's quoted. But the point is, my lord, that this record will have to, if the president relied on the intelligence report, and we don't know whether he did, your lordship is quite correct, if he relied on it, then he will have to file it. No, precisely, my lord. Precisely, my lord. Precisely, my lord.
I'm not sure why we're focusing on something that is so nebulous.
Because, my lord, the point I'm trying to make is this: if the intelligence report exists, And if the President had it before him when he made his decision, then when the Rule 53 record is filed, it will reveal that. And it will go to the applicant's case.
Only if he's willing to reveal. So he may even say to you, there is such a report. I did have regard to it, but I refuse to disclose.
My Lord, if he said...
Then there is another question, whether it's the adequacy of the report. And this is all based on the assumption that you succeed in it.
Absolutely, but my Lord, what I'm seeking to demonstrate is why I should succeed, which is that my client can't be expected to finalize its review grounds until it knows whether the President relied on an intelligence report and what it said. Now, if the President had filed a Rule 53 record and said, these are the things I took into account, in addition, I took into account an intelligence report, but I refused to disclose it on grounds of national security, then we would have a different debate. And that would be about whether one is entitled to withhold from a Rule 53 record something that is said to be in relation to national security. I don't want to prejudge that debate, because that's not the case that's been made out. The only point I make, my Lord, is that the record is critical, because it will reveal, and so are the reasons, it will reveal whether the President relied on an intelligence report or he didn't. And that is a matter that is fundamentally relevant to the question of whether the President's decision was rational. And indeed, unless the applicant knows that and the court knows that, it will be disabled from dealing with whether that decision was rational. And that's, I'm not asking your Lordship to comment on the intelligence report, to say it exists, to say it doesn't exist. But if it was before the President, then it must be filed as part of the Rule 53 record, and I would ask your Lordship to say that, because that is what... Well, to say that the President must disclose the record. Oh, yes, absolutely. But
then it's for you to say
yes. Oh, absolutely.
If I say he must disclose the intelligence report, then I'm already making a fine.
Oh, no, of course. No, of course, I misspoke. The only order that is sought is an order requiring him to file the record.
Yeah.
But that will in turn reveal whether the intelligence report was relied on or not. And that's the simple point that I make. No, and with respect, I don't need to for purposes of this application, because that is sufficient to justify my client's entitlement to the Rule 53 record. So, my Lord, that demonstrates why my client needs the Rule 53 record in order to supplement its papers and formulate its final grounds of review. And then the only remaining question on the Rule 53 record is whether the court gives it via Rule 53 or whether the court gives it via its inherent jurisdiction. And that is a debate, my Lord, that might be academically interesting, but is of no practical moment whatsoever. Because this court has been told expressly by the SCA, we've all been told, by the SCA in the spy tapes case, that if the record is not obtainable under Rule 53, then it must be obtainable under Section 173 of the Constitution. Could I just make the point that we would submit that on the existing authority, Rule 53 is broad enough to cover this decision. And that is made clear by the decision in Van Zyl versus the government, which we quote at paragraph 32 of the heads. That was the decision, my Lord, in which an individual had sought to review the South African government's decision to refuse diplomatic protection. The court made clear that it was an executive decision it was dealing with, just like in this case. It was there, and what the court said, far from what the President now wants to say, which is that Rule 53 doesn't apply at all, it said Rule 53 must be followed. At paragraph 32.3 of the heads, we say, the SCA held, review applications in the ordinary course of events have to be brought under Uniform Rule 53, and it complains that that was not the case. And then the court went back to say, because what happened in that case, of course, my Lord, is it wasn't brought under Rule 53. The President then disclosed certain things in his answering affidavit, and the applicant tried to fix up their case in reply. And the SCA said that's not permissible. And they criticized the applicant. The justification for the new case was the fact that they did not have the government's internal documents when the application was launched. The answer to this is that had they bothered to follow Uniform Rule 53, they would have had the documents before the answering affidavit was filed. They would have been entitled to amplify their founding affidavit, and the case would have proceeded in an orderly manner without complications. That is exactly what this interlocutory application seeks to achieve. It seeks to achieve a situation whereby the applicant gets access to the documents which are before the decision maker, can supplement its case accordingly, and then the matter can proceed without complications. And we make the point that a similar approach is taken in superior court practice and we've given your lordship the pages, where the court explains, Rule 53, my lord, is a rule that has existed for many, many years. I must confess, I didn't check when it first came into existence, but long before the Constitution. My lord, I don't propose to go there now unless... Yes. Yes, but the point I make is simply this. It is an old rule. It is a homegrown rule, and an old homegrown rule, and it must now be interpreted in light of the Constitution. Because when it was enacted, of course, Rule 53, there was no review for legality under the Constitution. There was no constitutional supremacy. And the point that is made in superior court practice is that the meaning of review has changed in light of the constitutional principles. And so we would submit that in accordance with the constitutional principles, Rule 53 must be given a broad reading to include... Yes.
One of the questions that came to the fore in my mind was this. Are you really asking me to read into Rule 53? Are you asking? Because if you look at Rule 53,
yes. Yes, of course, my lord. It is in the bundle of authorities on the first page.
Proceedings to be brought under review of an imperial court, of a tribunal, a board, an officer performing judicial, quasi-judicial, or administrative functions.
Yes.
In merely matters. Are you asking me to now say an executive decision? So you say an officer performing judicial, quasi-judicial, administrative or executive function?
My lord, you could reach the conclusion that way. The other way of reaching the conclusion is to understand that administrative functions there referred to the existing state of our administrative law, which is you could only review someone doing administrative functions. That's why I make... Well, we do, and we accept that this... No. Yes. Yes. The point I'm making, my lord, is that the courts, the highest courts, have not sought to place emphasis on the word administrative there. When you think about the Helen Suzman Foundation case, the JSC is certainly not performing judicial, quasi-judicial, or administrative functions. And yet, the court held that Rule 53 was applicable. When you think about when one thinks about the Van Zyl versus the government case, there again, a decision on whether to provide diplomatic protection was certainly not judicial, quasi-judicial, or administrative functions. It was executive in nature. And the court held not only that Rule 53 could be used, but had to be used. So what I'm submitting to your lordship is that the court seemed to take a broad reading of that phrase, presumably because when the rule was first enacted, you could only review an administrative functionary, not an executive functionary. And so the court treats it as applying to the review as Meyer, Deputy President of the SCA, held in the Helen Suzman Foundation case. Her language is interesting. She says, it enables the party to seek review of an inferior court, administrative functionary, or state organ. So she seems to just deal with it more broadly. She doesn't squarely consider this word, but she does speak about administrative functionary or state organ. So the approach that the highest courts have taken again and again is that Rule 53 even applies to a body which is not administrative in nature. So we would submit that it is capable of such a reading. But if it's not, could I assume against myself for a moment that it is not? Then we say that the answer is squarely given by the SCA in the spy tapes case. And we have quoted it for your lordship at paragraph 35.4. And it's the passage I've already read, your lordship, but if your lordship would forgive me if I could just read the relevant passage again. The court there was grappling with the issue your lordship was grappling with, which is, does Rule 53 apply in a legality context? Because again, the decision to withdraw prosecutions or not to charge was not subject to pudger at all. It was subject only to legality. And the court said, in the constitutional era, courts are clearly empowered beyond the confines of pudger to scrutinize the exercise of public power for compliance with constitutional prescripts. That much is clear from the Constitutional Court judgments set out above. And then here's the important point. It can hardly be argued that in an era of greater transparency, accountability, and access to information, a record of decision relating to the exercise of public power that can be reviewed. Could I pause there? Lord, it's common cause that this is the exercise of public power that can be reviewed. So it can hardly be argued that a record of decision relating to the exercise of public power that can be reviewed should not be made available, whether in terms of Rule 53 or by the courts exercising their inherent powers to regulate their own process. And so,
Move on to the question of why you made
the reasons.
Yeah, the reasons.
Thank you, my Lord. So, my Lord, the question of the reasons is as follows. Rule 53 in terms, and if I could just return to it for a moment, Rule 53 says that the decision maker must give the record together with reasons, together with the...
So, only entitled to reasons if we come to the conclusion
No,
that Rule 53 applies,
no,
but that you're not exercising the discretion of Rule 53.
no. I would submit, my Lord, that my client is entitled to it in either instance, and it's because the reasons are it's because the justification for reasons are the same. The reason we give reasons, the need for reasons in a review, is so that the party bringing the review knows what was before the decision maker and what the reasons for that decision were. Because without knowing the reasons, you cannot properly formulate your irrationality challenge. And I'm going to take your Lordship to the Cape Bar Council case in a moment to demonstrate that. My submission is that it is essential for there to be reasons alongside the record, because if the record is given without the reasons, then the party bringing the review doesn't know what the President made of those documents. Can I give your Lordship an example, hypothetical? Suppose that there are two documents before the President, and one suggests that the Minister of Finance is doing a splendid job, and the other suggests that the Minister of Finance was doing a terrible job, just hypothetically. Those documents would both have to be disclosed as part of the Rule 53 record. But the question is, what did the President make of them? Why was it that he preferred the document which required, that said that the Minister of Finance is doing a terrible job? Why was he persuaded by that document, at least in brief? And that is what the reasons reveal. And in that regard, what is critical, my Lord, is that a review in this context is about rationality or irrationality. And the SCA has said expressly that without reasons, you cannot interrogate rationality. Could I take your Lordship to that case? And that is the decision, again outside a Pudger context, of the Cape Bar Council, I beg your pardon, Judicial Service Commission versus the Cape Bar Council, which we have cited to your Lordship at page 16, paragraph 37.3. Now the issue there, let me say immediately, my Lord, it wasn't a case about Rule 53, because that wasn't the issue, but it was a case about whether the JSC was obliged to give reasons for its decision. And the argument of the JSC was when it appoints judges, it doesn't have to give reasons because it's under no express obligation to do so. And the court said that there were two key premises. This is the first quoted paragraph. First, that the JSC is under a constitutional duty to exercise its powers in a way that is not irrational or arbitrary. That applies here too, of course. Second, that because the JSC is an organ of state, it is bound by Section 195 of the Constitution to the values of transparency and accountability. That also applies here. And then the court goes on. But once these premises are accepted as valid, I cannot see how the inference of an obligation to give reasons can be avoided. It is difficult to think of a way to account for one's decisions other than to give reasons. And then it carries on. As to rationality, I think it is rather cynical to say to an affected individual, you have a constitutional right to a rational decision, but you're not entitled to know the reasons for that decision. How will the individual ever be able to rebut the defense by the decision maker? Trust me, I have good reasons, but I'm not prepared to provide them. Exemption from giving reasons will therefore almost invariably result in immunity from an irrationality challenge. We say, my Lord, that that applies precisely in this case. Once it is accepted that the President, and it is accepted that the President's decision has to be rational, how can the applicant be able to exercise its rights to review that decision and to challenge the rationality without being told what those reasons were? Rationality, as your Lordship knows, is all about reasons. And yet at the moment the applicant is entirely in the dark as to what the reasons are. And it's also no answer, of course, for the reasons to come in the answering affidavit, because then we're back to precisely the problem that Van Zyl alluded to. You've now got to change your case in reply, then you're criticized for changing your case. The whole reason that Rule 53 requires a record and reasons at an initial stage is to make sure that you finish your case. Your Lordship has done many reviews. Your Lordship has the point. So we would submit that there does need to be reasons for the decision. What those reasons are, we don't know. But that is the very point of this application, is to obtain the reasons. So, my Lord, for all of those reasons, we submit that your Lordship should make an order requiring the President to produce both the record and the reasons. And we do seek an order for costs, including the costs of 2 counsel, where 2 were employed. My Lord, given the urgency with which this matter was brought and the complexity of the main application, we submit that it was. I see my learned friend, President has 2 silks, my Lord. We're short of either of those. But Mr. Sikakani is indeed a silk, my Lord. It has, my Lord. I attended a silks party which congratulated him, so I can confirm it from the bar that he is indeed a silk, my Lord. So, my Lord, we do seek an order including the costs of 2 counsel, and we ask that the President be directed to provide in very short order both the record and the reasons. Thank you, my Lord.
Court is adjourned.
All right.